Good morning. Happy Saturday. There was a conversation between Kate and Mr. Stout and me on, what was that, the 5th? It was initially intended, I guess, to be a debate on whether or not you could automatically determine that every city hall is a limited public forum without regard to any other facts other than the name of the building. Prior to going live, Mr. Stout said that he wanted a less formal conversation, and I agreed to that, and Kate was just there for the ride. During the conversation, Mr. Stout came up with a novel new understanding of what frauditors do, and frauditors do things like film post offices and other governmental but non-federal buildings. And somehow that is different in Mr. Stout's understanding than filming inside of federal buildings, like the DEA building. And I found that to be odd, and Mr. Stout believes that the 2018 DHS memo, which is actually a 2018 Federal Protective Service memo. The Federal Protective Service is a sub-agency of the Department of Homeland Security. He seems to believe that this authorizes the filming of all federal buildings. Somehow that excludes post offices, which are also federal agencies. The Post Office, United States Post Office, is an independent agency of the federal government. And oftentimes, post offices will be located on GSA property, General Services Administration property. And we'll get there, I guess. But his understanding just really boggled me. And so I figured if it was boggling him, it might be boggling other people. And so let's get unboggled. First of all, let's kind of get our understanding of what's going on here. You'll notice that it says photography for news, advertising, or commercial purposes governed by 41 CFR 102-74.420. 41 CFR 102-74.420. What is a policy concerning photographs for news, advertising, or commercial purposes? You'll see that it's located within Subpart C, Conduct on Federal Property, which is located in Part 102-74, Facility Management, which is located under Subchapter C, Real Property, which is located under Chapter 102, Federal Management Regulation, which is located under Subpart C, Federal Property Management Regulation System, which is located under Title 41, Public Contracts and Property Management. So, what is Title 41 about? Title 41, Subchapter C, is these right here, and 102-71.5, well, let's do general. This is the General Service Administration's real property policies. We're dealing with the General Service Administration. This chapter deals with the General Services Administration. So, what is the scope and philosophy of the General Service Administration's real property policies? GSA's real property policies contained in this part and parts 102-72 through 102-82 of this chapter, and 102-72 to 102-82, this does fall within that range, apply to federal agencies, including GSA's Public Buildings Service, PBS, operating under or subject to the authorities of the administrator of the General Services. So they have to be operating under or subject to the authorities of the Administrator of General Services. These policies cover the acquisition, management, utilization, and disposition of real property by federal agencies that initiate and have decision-making authority over actions for real property services. The detailed guidance implementing these policies is contained in separate customer service guides. So now we know we have three things going on here. We have the General Service Administration. That's one agency. We have the Department of Homeland Security. That's an agency, or it's a department technically. And we have the Federal Protective Service. So how do those kind of relate to each other? Well, this is from the Library of Congress, so I hope you accept it as an authoritative source, loc.gov. You'll see up here, loc.gov. And you'll see that the Department of Homeland Service, DHS, is a department that is under the control of the executive branch. Now there are also independent agencies. And one of the independent agencies is the GSA. And that's right here, General Services Administration. The independent agencies are things like the Post Office. The Post Office is another independent agency, USPS. And the Social Security Administration, Office of Governmental Ethics. There's Small Business Administration, Amtrak. Amtrak is in here somewhere as an independent Amtrak is an independent agency. Don't I have it listed here? National Railroad Passenger, yeah. So it's an independent agency. National Endowment for the Arts. So it's different from, it is not a part of the Department of Homeland Security. It is an independent agency. As far as the Federal Protective Service, this is the Federal Protective Service's website. Let me make that a little bit bigger for you. You can see that it is under dhs.gov/Federal Protective Service. The Federal Protective Service is a sub-agency, or is an agency under the Department of Homeland Services. So about DHS, woo. So when we go back to the 2018 DHS FPS memo. This is a memo that is prepared by the Federal Protective Service that is for, here's the dissemination list, it's for Federal Protective Services personnel and I think those are public security officers or private security officers, basically security guards, FPS personnel and security guards nationwide. This is for FPS internal use only. Now, they have released this. There is a redacted version that they've actually authorized for full release. Road Pirate Films, I believe is her name, got me a copy of the unredacted version. I used to have a copy somewhere, but I lost it, so oops, my bad. So you can see that even though this is referencing GSA policies, that 41 CFR is a regulation that was prepared by the GSA to further their policies. It is not a GSA memo, and it's not specifically a DHS memo. It doesn't apply to all DHS sub-agencies. It doesn't apply to the entire Department of Homeland Security. It was created by the Federal Protective Service for the Federal Protective Service. And the Federal Protective Service provides basically their federal police. They provide policing for federal buildings that don't have their own. Like courthouses are going to use U.S. Marshals. Other agencies may have their own services or their own internal police, like the Department of Homeland Security, or not the Department, the Department of Defense. They have their each armed forces has their own military police or variation on the name for military police that provide security for the Department of Defense locations. So we know who the players are, and we know that the scope of these policies only apply to federal agencies operating under or subject to the Administrator of General Services. Now, the FPS, even though it's under the Department of Homeland Security, their job is to protect federal buildings. So they are operating under or subject to the Administrator of General Services. Okay. Now let's go back to the memo. So this is photography and videotaping federal facilities. Warning: this document shall not be distributed or released outside the Federal Protective Service and its protective security officer vendors without express approval from headquarters. So again, this is reaffirming that this memo, it's not law. This is not law, by the way. This is a memo. This is something that they wrote up internally to hand out to their officers, just as kind of like a guideline. This isn't law. A court doesn't care about this, other than it would want to hold FPS agents to this, and it would use this to determine whether or not they had notice of certain things and things like that. But this is not going to grant anybody rights. All right, so background. Photography for news, advertising, and commercial purposes is governed by 41 CFR 102-74.420. Now we know, again, that 41 CFR 102, that is a section, dash 74.420, that is a section of regulations that are promulgated by the GSA. And what does it say? And that is this. It says, except where security regulations, rules, orders, or directives apply, or a federal rule or order prohibits it. So if a security regulation applies, then this doesn't. If a rule applies, then this doesn't. If an order applies, then this doesn't. If a directive applies, then this doesn't. If a federal court order or rule prohibits it, then this doesn't apply. But if there are no security regulations that prohibit filming, if there are no rules that prohibit filming, if there are no orders that prohibit filming, if there are no directives that apply that prohibit filming, or there are no federal court orders or rules that prohibit filming, then, and only then, persons entering in or on federal property may take photographs of A, space occupied by a tenant agency for non-commercial purposes only with the permission of the occupying agency concerned. So if you go into space that's occupied by a federal agency for non-commercial purposes, you have to have their permission to film. It doesn't matter what you consider that space to be. If it is occupied by a tenant agency, the GSA, much like the post office, they make money. They're designed to make money, and they charge agencies rent. And they might also have non-federal agencies in their buildings. They might have other commercial enterprises in their buildings, but they charge agencies and other tenants rent. They lease these spaces out. And if, just like for example, if you rent an apartment in an apartment building, you get to control what happens inside of your apartment. Now, your apartment may have a foyer, but it's your foyer, and you get to control what happens in your apartment. Your apartment may have a corridor in it, a hallway. If you have a big enough apartment, you may have a lobby or an auditorium in it. Could happen. But if it's in your apartment, it's yours to control. Now, what you don't control in the apartment building are the common hallways, the common entrances, the common foyers. Those are going to be governed by the policies of the management, the property manager for the apartment complex. But inside your area, you get to control the entire thing. Now, if you purchase the entire, or you lease the entire building, the entire apartment building, then you get to make the policies for the entire apartment building because it's all yours now. You've leased the entire thing. So Space occupied by tenant agency for non-commercial purposes only with the permission of the occupying agency concerned. Space occupied by a tenant agency for commercial purposes only with written permission of an authorized official of the occupying agency concerned, and building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. Now, again, if it is in space occupied by an agency, those are going to control, and if it's not, then this is going to control. In October 2010, FPS disseminated an FPS information bulletin to the field addressing the photographing of the exterior of federal facilities. The purpose of the bulletin was to remind FPS personnel and PSOs that the public has the right to photograph the exterior of federal facilities from public forums. Now, you know this isn't a legal document because it says public forums. It doesn't say traditional public forums. It doesn't say non-public forums. It doesn't say designated public forums. It doesn't say non-public forums. It just says public forum, so I don't know what that means. My best guess is what they're saying is from the traditional public forum, you can take whatever pictures you want to of the federal building. Because you're on a traditional public forum, they don't have the right to regulate you there. The occupying agencies don't have rule-making authority to regulate what you do on the city street or on the city sidewalk. Since the publication of the bulletin, FPS has experienced an increase in the public's interest in photographing and videotaping both exterior and interior of federal facilities protected by FPS. See, again, we're talking about federal facilities protected by FPS because, once again, to remind you, I can't beat this in hard enough. This is a FPS memo that was disseminated to the FPS. It is for the FPS. It is a memo, it's not law, and it's for the FPS. To include individuals expressing their First Amendment protected rights by intentionally photographing and videotaping the exterior and interior of a federal facility and law enforcement in the course of their duties to test FPS law enforcement and PSO response. Also, new case law impacts the interpretation and implementation of FPS enforced regulations. To address this increase in photography and videotaping by the public, this operational readiness order, this is an operational readiness order. This is an order to FPS personnel. This is their order. It's their memo. Reiterates the 2010 guidance, provides clarification on the public's right to photograph publicly accessible federal facility building entrances, lobbies, foyers, corridors, and auditoriums, and directs FPS law enforcement personnel and PSOs to maintain security without adversely impacting the public's rights relating to photography and videotaping. Police and FPS agents and PSOs, which are basically security guards, they have the police officer's knowledge of the law. They don't have a nuanced understanding of the law. They need kind of black and white sort of, if this happens, do this, if it doesn't happen, do that. Because that's more or less the area that they operate under. You know, if it's a gray line kind of thing, they will err on the side of making the arrest and letting the prosecutor, if it's a DA or a U.S. attorney, whoever the prosecuting attorney is, they'll let them figure out whether or not to press charges. They'll let somebody else figure out whether or not to press charges. They just need kind of black and white sort of, if you're on this side of the line, I'm going to let you do your thing. If you're on the other side of the line, I'm going to react and arrest you. Photographing the exterior of federal facilities. For properties under the protective jurisdiction of FPS. What is that saying? Again, this is by, for, and about the FPS and about how they are interpreting the law. So this only applies to properties under the protective jurisdiction of the FPS. Actually, it only applies to the way the FPS deals with it, if it's under their protective jurisdiction. It doesn't necessarily impact what the agencies inside are going to deal with, or how the U.S. government, the U.S. attorney, may or may not decide to charge someone, even if the FPS may refer someone to a grand jury, even if the FPS doesn't make the arrest and there. There are currently no general security regulations prohibiting exterior photography of any federally owned or leased building absent a written local rule or regulation established by a court security committee or in limited cases a facility security committee. So what it's saying here is there's no general security regulation over it. The GSA has not promulgated some sort of a regulation that says you can't photograph the exterior of a federally owned building. Furthermore, it is important to understand that 41 CFR 102-74.420 does not prohibit photography by individuals of the exterior of federally owned or leased facilities. Rather, this regulation describes when an individual may photograph the interior of federally buildings. The interior of federally buildings. It was such a nice memo, too. Federally buildings, i.e. space occupied by a tenant agency or building entrances, lobbies, foyers, corridors, or auditoriums. Therefore, absent reasonable suspicion or probable cause indicating criminal activities, law enforcement and security personnel must allow individuals to photograph the exterior of federally owned or leased facilities from publicly accessible spaces such as streets, sidewalks, parks, and plazas, even if federally owned or leased. Now, once again, this is the order to FPS personnel, and also remember that there again may be court security committees or federal or facility security committees that have promulgated written local rules. So be careful. Be careful. This right includes the ability to photograph any exterior security countermeasures that are viewable to the public and can be photographed or videotaped from publicly accessible spaces. This right includes the ability to photograph from exterior property under the control of the federal government, such as sidewalks, plazas, and parking lots, if such property is publicly accessible. As a reminder, photography and videotaping absent a criminal predicate is a First Amendment protected activity. Mere photography or videotaping of the exterior of federal facilities without the presence of any other indicators of nefarious activity is not a reportable suspicious activity under the National Suspicious Activity Reporting Initiative, made through Suspicious Activity Reports, SARS. DHS's Office of Civil Rights and Civil Liberty requires the photography or videotaping be performed in an unusual or surreptitious manner that would arouse suspicion of terrorism or other criminality in a reasonable person before conducting an investigative detention. Photographing the interior of federal facilities. I think this is the meaty part. Title 41, Section 102-74.420 of the Code of Federal Regulations provides federal policy concerning photographs for news, advertising, or commercial purposes. It states, except where security regulations, rules, orders, or directives apply, or a federal court order or rule prohibits, persons entering in or on federal property may take photographs of. Everybody wants to start off with this part, and they want to say, oh, we may take photographs of this stuff, but it doesn't start there. It starts off with except where there are prohibitions against it. Space occupied by the tenant agency, space occupied by the tenant agency, and then buildings, entrances, lobbies, foyers, corridors, etc. So we've already read those. We already understand that you need the permission of the tenant agency, just like if you walked into somebody's apartment, if you go into the area that it is leased by that tenant agency, you need their permission to film. And it's either going to be just verbal permission or written permission, depending on whether you're filming for commercial or non-commercial purposes. Otherwise, if it's not area that's leased by a tenant agency, if it's general areas that all of the agencies inside the building use, like if there's multiple agencies, the common areas you can film for news purposes. In applying this regulation to FPS protected facilities, FPS, and this, I don't know exactly what this means. Honestly, I don't know exactly what that means. What is news purposes? Is B-roll footage for news purposes? It sounds like it to me. This sounds like it sounds like something that people think means something, but it doesn't actually mean something. But that's just me, because I'm being dumb. In applying this regulation to FPS-protected federal facilities, again, this is how the FPS applies it to FPS protected facilities. FPS law enforcement personnel and PSOs should consider the following information when contemplating enforcement of the regulation. So the regulations accept where regulations, rules, orders, or directives apply, or federal court order or rule prohibits it. Persons entering in or on federal property may take photographs of ... Application. Photography and videotaping the interior of federal facilities is allowed under the conditions set forth in A to C of the regulation unless there are regulations, rules, orders, directives, or a court order that prohibit it. For example, the Social Security Administration has rules that prohibit photography and videotaping in its spaces. Similarly, many courts issue no photography or videotaping in courtrooms and surrounding areas. They issue, I'm going to say, orders regarding no photography. The prohibition must be clearly posted, or actual in-person notice must be given in order to be enforced. So if they say, hey, don't film here, that's in-person notice. Then subsection A, space occupied by a tenant agency for non-commercial purposes only with the permission of the occupying agency concerned. Non-commercial photography and videotaping in space occupied by a federal tenant, in space occupied by a federal tenant, if they occupy the entire building, that would be space occupied by a federal tenant, requires a verbal permission of the federal tenant. For example, a visitor to an Army Corps of Engineers office has verbal permission from the office manager to photograph the private promotion ceremony of a friend. A student is given verbal permission from the office manager to take photographs of the office for a school project. That's what they're looking for. They're looking for verbal permission from someone who should be able to give permission. B, space occupied by a tenant agency for commercial purposes only with the written permission of an authorized official of the occupying agency concerned. Commercial photography and videotaping in space occupied by a federal tenant requires the written permission of the agency official authorized to approve commercial photography and videotaping. Journalists, news media, or other individuals photographing or videotaping for news purposes is not considered a commercial purpose. So as far as the FPS is concerned, if you are filming for news purposes, then that's not considered a commercial purpose. Even though the local news agency is going to put this on their news program and they're going to monetize it by running ads, the FPS does not consider that to be commercial purposes. For example, a professional photographer has obtained written permission from a designated official at a building housing only Department of Interior offices to photograph architectural design work performed by one of the photographer's clients. So here's a good example of where a agency occupies the entirety of the building. So in this case, it is a Department of Interior building. They own a building housing only Department of the Interior. And so the Department of the Interior has to give this commercial photographer written permission to photograph the architectural design work. A movie company is given written permission from the designated official to videotape a federal facility. And then subdivision C, building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. Due to the expansive use of social media, the vast majority of the public is considered to be gathering news to include how the federal government functions. Again, this is the FPS's interpretation for FPS police officers, essentially. Recognizing this fact, the public is allowed to photograph interior building entrances, lobbies, foyers, corridors, and auditoriums from publicly accessible areas. For example, someone can photograph in the common space and publicly visible or publicly accessible lobby of a federal facility. This includes videotaping any countermeasures, including the security screening posts. So this, again, think of this like an apartment complex. Inside the area that is leased by each tenant, the tenant gets to dictate what happens. In the common areas, then the building manager, the property manager, gets to dictate what happens. If someone owns or leases the entire building, then there are no common areas anymore because it's been unified. All the areas inside the building are for the use and enjoyment of the one person who leases the entire building. If an individual is authorized to photograph or videotape the interior of a federal facility as discussed above, this right includes the ability to photograph or videotape any interior security countermeasures, including security screening posts, which are viewable to the public and can be photographed or videotaped from publicly accessible spaces. So if you have been given the right, or if you're authorized to photograph, then you can photograph whatever you can see. This right, however, does not authorize a photographer to intrude on a restricted space surrounding security posts, create loud or unusual noises, or cause a nuisance, obstruct the usual use of entrances, lobbies, and other commonly accessible space, impede or disrupt the performance of official duties by government employees or federal contractors, including the PSOs, nor prevent the public from obtaining government services provided in the facility in a timely manner. What the, quote, anti-frauditor, end quote, people do is they commonly conflate the act of filming with the act of creating loud or unusual noises. They conflate the act of filming with causing nuisances. They conflate the act of filming with obstructing the usual use of entrances, lobbies, and other commonly accessible spaces, impeding or disrupting the performance of official duties by government employees or federal contractors, including PSOs, and they conflate it with preventing the public from obtaining government services provided by the facility in a timely manner. Rather than conflating filming with all of these other things that are not filming, instead, you should consider filming in light of someone who's not being an ass. In all of my audits, I was not an ass. I was not obtrusive. I didn't get arrested. I asked politely for permission to film inside the post office. I've taken, I don't know if I published any of it in videos, but I've taken, maybe I did, but in the Auburn County Courthouse, or in the Auburn Courthouse, Placer County, it's a super old, it's like 1880-ish building. I mean, they have a portrait of President Lincoln in it. So it's a very old building, and it has amazing architecture inside of it. And I have, with permission of a judge, taken video in one of the courtrooms of the architecture inside of it, because it's gorgeous. Again, don't conflate the act of filming, or instead of being polite, maybe just consider someone conducting their business there. They go in to the DEA's office to file a complaint or to do a public records request or something like that, and they wear a body cam. Unobtrusive, but visible, just a chest-mounted body cam. And otherwise, they act completely normal, like every other person going into that office to do the business that office is intended to allow them to do. I know this would blow Mark Stout's mind, but that is not causing any problem to anybody, unless there is some reason to not allow filming. Like, I completely understand in the Social Security Administration that they would not allow anybody to film in there because they don't want people to capture other people's personally identifiable information. The combination of someone's name, date of birth, and social security number can get you a lot of things that maybe they don't want you to have. It might allow you to open up like bank accounts in their name or get credit cards in their name. So I can understand why the Social Security Administration would want to limit or restrict or not allow entirely videotaping or audio recording inside of their locations. So always dissociate filming with all the other disturbances that some of the auditors or frauditors like to do accompanying their filming. Assuming the best possible behavior plus filming, would it be unreasonable to force that person, the very reasonable person with the camera, would it be reasonable to restrict their filming in that situation? And I think you can see with the Social Security Administration, it would be reasonable to restrict their filming, but someplace where you're going to get public records or something like that, maybe it's not. Guidance for FPS law enforcement officers encountering individuals taking photographs of the exterior and interior of federal buildings. The guidance, I don't think, this is just how they react to it. Guidance for PSOs, this is how they react to it. Analysis, I don't really care much about this. And yada, yada. For official use only. This document is for official use only, yada, yada. So I think we've covered everything that I wanted to cover on that. That was the scope, what it applies to, rules and regulations governing conduct on federal property. Again, since this is in Part 102-74, this is GSA stuff. There is something in here that I thought was interesting that people should be aware of, and that's this right here. Impact on other laws or regulations. This is referencing 41 CFR 102-74.455. No rule or regulation in this subpart may be construed to nullify any other federal laws or regulations or any state and local laws and regulations applicable to any area in which the property is situated. So if an agency has its own regulations governing its areas, the areas under its control, then it can enforce those, and these don't nullify it. And I think that was it. That was all I really wanted to have on that. The language in 41 CFR Part 102-74 is basically identical, very similar to the CFR 39 CFR, the one for the post office, that their appendix. It's basically the same. Now, one other thing that I wanted to touch on is there always has to be some sort of a statutory authority for a CFR. CFRs don't just exist without some sort of a statutory authority. Now, it's not always clear here in cornell.edu's website, but you can see that in the govinfo.gov, they will list the references to various statutes. So Congress passes statutes. These are statutes that that particular section relies on. 40 USC 121, 40 USC 581, 40 USC 1315, and see 40 USC 1315, law enforcement authority of the Secretary of Homeland Security for protection of public property. Why does the Federal Protective Service, which is Department of Homeland Security, protect GSA properties? Why do they do that? Well, it's because there is a statute, 40 USC 1315, that says that they do that. Without authority conferred to the agency by Congress via a statute, a law, these are the public laws that were done. They're codified. They're just codified in the U.S. Code. And so like Public Law 95-454, that was, where are you going to go to find that? But the way they organize the U.S. Code, like Section 40 is about the GSA, I think, or it's about federal property, yeah. And let's just go back to the entire U.S. Code. Like 18 is all crimes and criminal procedure. Title 11 is bankruptcy. So the U.S. Code takes all of the public laws that are relevant to, let's say, Indians, and it places it in the 25 USC and organizes it in such a way that you can go to find it in a fairly easy fashion. A lot of people like to say that codes aren't laws. Well, they're codified laws. They're placed in context with each other. They just take the direct language of the law and they place it in context. And that's what GovInfo does. Is it gives you an idea of what these things are, and where they apply, and where the authority for various things come from. So that's something that Mr. Stout wasn't really clear on. All codes of federal regulations, yes, they do carry the force of law, but they have to be authorized by Congress, because you have to remember, we have three branches of government: the legislative, the judicial, and the executive. And agencies underneath them can only make laws, regulations. Those are laws, but they can only make it insofar as they've been delegated that power by the legislative branch. Because these agencies are executive branch, so if they get delegated power from the legislative branch, they have some authority from the executive, they have authority from the legislative, and now they can do the things to make the regulations. And I think I've rambled on enough. If it's not clear, let me know. I did another video on this in 2018. I'll put a link to it in the description. It's much shorter. I probably should have said that up front. But yeah, thanks for watching. Have a great day.